Unit 3, Encumbrances on Real Property. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Identify different types of encumbrances on real property and different types of liens, easements, and encroachments. Explain property taxation laws and procedures, and how real property is assessed and taxed. Calculate various property taxes. Key terms: ad valorem taxes, assessment, deed restrictions, dominant tenement, easement, easement appurtenant, easement by necessity, easement by prescription, easement in gross, encroachment, encumbrance, general lien, judgment, license, lien, lien agent, lis pendens, machinery act, mass appraisal, mechanics lien, mill, octennial reappraisal, priority, servient tenement, special assessments, specific lien, tax lien, writ of attachment, writ of execution. Learning objective. Identify different types of encumbrances on real property and different types of liens, easements, and encroachments. Encumbrances on real property. There is no such thing as perfect title to land. Nevertheless, title should be marketable and insurable. Marketable title does not assume the absence of defects, but rather suggests that prudent, educated buyers would nevertheless accept it. Real property title will have certain flaws or impediments. Such flaws, such as claims, charges, or liabilities that attach to and are binding on real estate, are called encumbrances. An encumbrance is anything that affects title to real estate. It is a right or interest held by a party who is not the fee owner of the property. An encumbrance may affect the value or obstruct the use of the property, but it does not necessarily prevent a transfer of title. Tax liens and deed restrictions, for example, are common encumbrances that do not prevent a transfer of title. Liens, a non-possessory charge against property that provides security for a debt or an obligation of the property owner, is a lien. If the obligation is not repaid, the lien holder or creditor has the right to have it paid out of the debtor's property, usually from the proceeds of a court sale. Real estate taxes, mortgages and trust deeds, judgments, and mechanics liens all represent possible liens against an owner's real estate. A lien does not constitute ownership. It is a type of encumbrance. Note, however, that whereas all liens are encumbrances, not all encumbrances are liens. Liens fall into several categories based on how they are created. A voluntary lien is contractual or consensual and is created by the debtor's action, as when someone takes out a mortgage loan to buy real estate. An involuntary lien is created by law, such as a tax lien imposed by a municipality. Liens may be further classified as general or specific, as illustrated in types of liens. Types of liens. Specific liens. A specific lien is secured by a specific parcel of property and affects only that particular property. Examples would be mortgage or deed of trust liens, real property taxes or special assessments liens, and mechanics liens. Mortgage and deed of trust liens. In general, a mortgage or deed of trust lien is a voluntary specific lien on real estate given to a lender by a borrower as security for a real estate loan. It becomes a lien on real property when the lender records the mortgage or deed of trust in the office of the Register of Deeds in the county where the property is located. Mortgage and deed of trust liens are the most common form of lien or encumbrance. Mortgages and mortgage liens are discussed in detail in Unit 14. Real property tax and special assessment liens. If a property owner fails to pay the taxes levied by a city or county on the property, the unpaid tax becomes a specific, involuntary lien on that property. A lien attaches to the property on the date the property is listed and, as a superior lien, takes priority over all other liens. Real property is taxed on an ad valorem basis, which means according to value. In addition to the ad valorem real estate taxes, special assessment taxes may be levied against specific real property. The purpose of these taxes is to pay for an improvement that has benefited the taxed property, such as street paving or the installation of a sewer system. In North Carolina, both ad valorem and special assessment tax liens are valid for 10 years and have priority over other types of liens. Mechanics lien. The purpose of the mechanics lien is to give security to those who perform labor or furnish material in the improvement of real property. A mechanic's lien is a specific, involuntary lien and is available to contractors, subcontractors, architects, equipment lessors, surveyors, laborers, and others. This type of lien is filed when the property owner has not paid for the work or when the general contractor has been paid but has not paid the subcontractors or suppliers. To be entitled to a mechanic's lien, the person who did the work must have had a contract with the owner or the owner's authorized representative. A person claiming a mechanic's lien must file the lien claim within 120 days after last furnishing the labor or materials. The lien takes effect from the date that person first furnished the labor or materials. The action to enforce a properly filed mechanic's lien must be brought within 180 days after a worker last furnished labor or materials. Major changes were made to North Carolina mechanics' lien rights in early 2013. A property owner who applies for a building permit for improvements totaling more than $30,000 must designate an approved lien agent for the project. This includes all private residential and commercial construction projects except improvement to owner-occupied single-family detached property. Any mechanic lien filed receives special priority in order to protect the contractors. Any potential lien claimant must serve notice to the lien agent within 15 days of beginning work on the project or lose the lien priority afforded mechanics liens. Projects costing under $30,000 are exempt from requirement for a lien agent designation. Example timeline. A property owner hired a pool company to build a pool and started work on February 1, 2022. The project was completed on March 1, 2022, and the property owner refused to pay the pool company. The pool company must file the claim by July 1, 2022, but the effective date of the lien would be the start date of the project, February 1, 2022. The action to enforce the properly filed mechanic's lien must be brought by September 1, 2022. North Carolina Commercial Real Estate Broker Lien. A 2011 North Carolina law allows a real estate broker with a written agency agreement to represent a property owner in a commercial transaction to place a lien on the property to be sold or leased to protect the broker's commission. A lien must be filed in a sales transaction after the broker has fully performed but before closing. In a lease transaction, the broker has up to 90 days after tenant possession to file the lien. The lien must be satisfied within 18 months and is inferior to all mechanics liens. General liens. General liens affect all the property of a debtor, both real and personal, rather than a specific parcel of real property. Examples include judgments, personal property tax liens, and state and federal tax liens. Judgments. A judgment is a decree issued by a court. When the decree provides for the awarding of money and sets forth the amount of money owed by the debtor to the creditor, the judgment is referred to as a money judgment. When a judgment is properly docketed in a county, that judgment becomes an involuntary, general lien on all of the current and future real estate and personal property owned by the judgment debtor in that county. Real estate of the judgment debtor in other counties is not affected unless the judgment is docketed in those counties as well. In North Carolina, a judgment lien is good for 10 years from the date of the judgment. Personal property tax liens. A personal property tax is assessed on certain types of personal property. If unpaid, this tax becomes a general, involuntary lien against all the property owned by the taxpayer. Like real property tax liens, personal property tax liens have priority over other types of liens. State tax liens. Both unpaid state inheritance taxes and unpaid state income taxes give rise to general, involuntary liens against all property owned by the individual taxpayer. In North Carolina, both types of liens last for 10 years. Federal tax liens. An IRS tax lien results from a person's failure to pay any portion of federal IRS taxes, such as income and withholding taxes. A federal tax lien is a general, involuntary lien on all real and personal property held by the delinquent taxpayer. Its priority is based on the date of filing or recording. It does not supersede previously recorded liens. Effects of liens. Effects of liens on title. Although the fee simple estate held by a typical real estate owner can be reduced in value by the lien rights of others, the owner is still free to convey title to a willing purchaser. The purchaser will, however, buy the property subject to any liens because liens run with the land. That is, they will bind successive owners if steps are not taken to clear the liens. Remember, liens attach to the property, not to the property owner. Therefore, although a purchaser who buys real estate under a delinquent lien is not responsible for payment of the debt secured by the lien, the purchaser does face a possible loss of the property if the creditors take court action to enforce the payment of their liens. Priority of liens. Because property taxes and special assessments generally take priority over all other liens, they are called superior liens. Therefore, if the property is sold through a court-ordered sale to satisfy unpaid debts, outstanding real estate taxes, special assessments, and unpaid debts will be paid from the proceeds first. The remainder of the proceeds will be used to pay other outstanding liens in the order of the date and time they were recorded. The first lien to be recorded is the first lien to be paid. One exception to this rule is the mechanic's lien. The priority of a mechanic's lien dates back to the date the labor began or materials were first provided rather than to the date the lien was filed. Remember, real property tax and special assessments can move in front of or take priority over any of these recorded liens. Real property taxes are always the most superior lien. The normal recordation priority of mortgage liens may be changed by the execution of a subordination agreement, in which the first lender subordinates its lien to that of the second lender. To be valid, such an agreement must be signed by both lenders. Subordination agreements may be contained in the mortgage itself, or they may be separate agreements filed for recordation. Deed restrictions. Deed restrictions are another type of encumbrance on real property. Deed restrictions are private agreements placed in the public record that affect the use of land. They are usually imposed by the original developer of real estate when property is sold and are included in the deed to the buyer. Deed restrictions typically would be imposed by a developer or subdivider for the purpose of maintaining specific standards in a subdivision, and they would be listed in the original development plans for the subdivision filed in the public record. Deed restrictions are discussed further in Unit 6. Lis pendens. A judgment or another decree affecting real estate is rendered at the conclusion of a lawsuit. Generally, there is a considerable time lag between the filing of a lawsuit and the rendering of a judgment. When any suit is filed that affects title to a specific parcel of real estate, the person bringing the lawsuit may file a lis pendens. When a lis pendens is filed, anyone acquiring an interest in the property takes that interest subject to any judgment or decree the court may issue. Lis pendens is not a lien but rather a notice that there is an action or lawsuit pending that may adversely affect the title. The lis pendens acts more like an encumbrance against the title. Example: if a lender is filing a foreclosure suit against a property owner, it will file a lis pendens against the property. If the property owner should sell the property during the course of the legal action, the new purchaser would take title subject to the outcome of the foreclosure action. Writ of attachment. Another encumbrance against real property is a recorded writ of attachment for a debt other than a mortgage. A creditor can request the court to issue a writ of attachment against the debtor's unsecured property by ordering a lien on the debtor's assets until the lawsuit is decided and a judgment is rendered. The unsecured real estate remains available to satisfy the judgment. Once a judgment is recorded, a writ of execution will be issued directing the county sheriff to sell the property to satisfy the judgment. Easements. A non-possessory right to use the land of another for a particular purpose is called an easement. An easement is not a form of ownership. It merely grants the use of the property. Easement appurtenant. An easement that is annexed to the ownership of one parcel of land and used for the benefit of another parcel of land is an easement appurtenant. For an easement appurtenant to exist, two adjacent tracts of land must be owned by different parties. The tract over which the easement runs is known as the servient tenement or estate. The tract that benefits from the easement is known as the dominant tenement or estate. Easement appurtenant. Example: if Jake and Elwood own adjacent properties in a lake resort community, and only Jake's property borders the lake, Jake may grant Elwood an easement across Jake's property so that Elwood can have access to the lake. Jake's property is the servient tenement. Elwood's property is the dominant tenement. Elwood's property benefits from the easement because it now has lake access, which did not exist before the easement was granted. An easement appurtenant is considered part of both the dominant and the servient lands, and if either tract is conveyed to another party, the easement passes with the title. In legal terms, the easement runs with the land. In North Carolina, an easement must be recorded to be enforceable against the purchaser of the servient estate. A party wall can be an exterior wall of a building that straddles the boundary line between two lots, or it can be a commonly shared partition wall between two connected properties. Each lot owner owns the half of the wall on their lot, and each has a cross easement in the other half of the wall. A written party wall agreement should be used to create the easement rights. Expenses to build and maintain the wall are usually shared. A party driveway shared by adjoining owners and straddling the property boundary also should be created by written agreement, specifying responsibility for expenses. Easement in gross. A personal interest in or right to use the land of another is an easement in gross. An easement in gross benefits a person or an entity, not a parcel of property, so there is no dominant tenement or estate. Examples of commercial easements in gross are the easement rights a railroad has in its right-of-way, billboards easements, or utilities easements. The railroad company, the billboard owner, or the utility company receives the use and benefit of someone else's land, while the land subject to the easement receives little or no benefit. Commercial easements in gross, such as the ones mentioned, may last an indefinite period of time and may be assigned or conveyed. Because North Carolina treats an easement in gross as a personal right, personal easements in gross are irrevocable during the owner's life, usually are not assignable, and terminate on the death of the personal easement owner. Easement in gross. Creating an easement. There are 3 ways that easements can be created. The first method of creating an easement is by express grant. This occurs when the servient owner gives an easement either by spoken or written words to the dominant owner. Typically, this easement is created by a written agreement between the parties that establishes the easement right. The creation of an easement always involves 2 separate parties, one of whom is the owner of the land over which the easement runs. The second method of creating an easement is by implication. An easement that is not created by express statements between the parties, but as a result of surrounding circumstances that dictate that an easement must have been intended by the parties. These are sometimes referred to as implied easements. An easement by necessity is an example of an easement by implication. The third method of creating an easement is by operation of law. The phrase by operation of law is a legal term that indicates that a right or liability has been created for a party, irrespective of the intent of that party, because it is dictated by existing legal principles. An easement by prescription is an example of an easement created by operation of law. The person who has the easement interest has a non-possessory interest with the right to use the land. The owner of the land burdened by the easement has a possessory interest in the land, but the owner cannot interfere with the easement holder's rights of use. Necessity. An easement by necessity or easement by implication of law arises because all owners must have rights of ingress to and egress from their land. They cannot be landlocked. If a grantor has conveyed property that is completely surrounded by the grantor's property, an easement by necessity will be created. Prescription. When a claimant has made use of another's land for a certain period of time, as defined by state law, an easement by prescription is acquired. This prescriptive period is 20 years in North Carolina. The claimant's use must have been continuous, exclusive, and without the owner's approval. Additionally, the use must have been visible, open, and notorious, so that the owner could have readily learned of it. A property owner can prevent an easement by prescription from being created by giving permission to the user. Terminating an easement. An easement may be terminated when the purpose for which the easement was created no longer exists. If the easement holder becomes the owner of the land where the easement is located. I release of the right of easement to the owner of the servient tenement. I abandonment of the easement, or by non-use of a prescriptive easement. Licenses. A license is a personal, non-transferable privilege to enter the land of another for a specific purpose, such as a license for a friend to hunt on a farmer's land during the winter. A license differs from an easement in that it can be terminated or revoked. Generally, if the right to use another's property is given orally or informally, it is considered to be a license rather than an easement. Because a license is not considered to be an interest in the land itself, it is not considered an encumbrance. A license automatically ends with the death of either party or with the sale of the land. Encroachments. An encroachment arises when an improvement or any portion of an improvement, such as a building, fence, or driveway, illegally extends beyond the land of its owner and covers some land of an adjoining owner, street, or alley. For instance, two landowners are neighbors. The garage of one landowner actually extends 1 foot onto the neighbor's property. This is an encroachment. Encroachments are usually disclosed by either a physical inspection of the property or a location survey. A location survey shows the location of all improvements on a property and determines whether any improvements extend over the lot lines. If the building on a lot encroaches on neighboring land, the neighbor may be able either to recover damages or secure removal of the portion of the building that encroaches. Encroachments of long standing may give rise to easements by prescription. The primary reason for a property survey is to ensure no encroachments have occurred. A legal effect of an encroachment is to potentially make both titles unmarketable. Here is an example of a survey. In practice, because an undisclosed encroachment could render a title unmarketable, the existence of an encroachment should be noted in a listing agreement, and the sales contract governing the transaction should be made subject to the existence of the particular encroachment. Encroachments are not disclosed by the usual title evidence provided in a real estate sale unless a survey is submitted while the examination is being made. Mortgage lenders may resist loans on properties with encroachments. Watch the video to learn more about encroachments. Learning objective. Explain property taxation laws and procedures, and how real property is assessed and taxed. Property taxation. The ownership of real estate is subject to certain government powers. One of these powers is the right of state and local governments to impose tax liens for the support of their governmental functions. Because the location of real estate is permanently fixed, the government can levy property taxes with a high degree of certainty that the taxes will be collected. Furthermore, because the lien for property taxes levied on real estate has priority over other previously recorded liens in most states, the property tax lien will almost always be the first lien to be paid from the proceeds of a court-ordered sale of the real estate. In North Carolina, a property tax lien will have priority over all previously recorded liens except a previously recorded state income tax lien. Real estate property taxes fall into two categories: general real estate, or ad valorem, property taxes, and special assessment, or improvement, property taxes. Both of these property taxes are levied against specific parcels of property and automatically become liens on those properties. General tax. General real estate property taxes are levied for the general support of the government agency authorized to impose the levy. Property taxes are known as ad valorem taxes because the amount of the tax varies in accordance with the value of the property being taxed. North Carolina property subject to taxation. All real property in North Carolina is subject to taxation. Although counties and municipalities determine real estate property tax rates within their jurisdictions, the Machinery Act regulates standards for real property taxation, standards for property tax assessment, standards for property tax appraisal, and requirements for tax-exempt status. Property generally considered tax-exempt or eligible for special tax treatment includes that owned by nonprofit religious, educational, and charitable organizations, property owned by the elderly and handicapped, agricultural, horticultural, and forest lands, and some properties with energy-efficient heating and cooling systems. Assessment. Real estate is valued for property tax purposes by county or township assessors or appraisers. This official valuation process is called assessment. A property's assessed value is generally based on the sales prices of comparable properties, although practices may vary. Land values may be assessed separately from buildings or other improvements, and different valuation methods may be used for different types of property. In some states, assessed value may be less than market value, such as 80% of market value. The North Carolina Machinery Act mandates that assessed value is 100% of market value. State laws may provide for property to be periodically reassessed. Sometimes, a property owner believes that an error was made in determining the assessed property value, usually that the assessment is too high in comparison with the assessments of neighboring properties. Such owners may present their objections to a local board of appeal or board of review. Protests or appeals with regard to tax assessments may ultimately be taken to court. Tax rates. The process of arriving at a real estate property tax rate begins with the adoption of a budget by each taxing district. Each budget covers the financial requirements of the taxing body for the coming fiscal year. The fiscal year may be the January through December calendar year, or some other 12-month period designated by statute. The budget must include an estimate of all expenditures for the year. The next step is appropriation. Appropriation is the way a taxing body authorizes the expenditure of funds and provides for the sources of the funding. Appropriation generally involves the adoption of an ordinance or the passage of a law that states the specific terms of the proposed taxation. The amount to be raised from the general real estate property tax is then imposed on property owners through a tax levy. A tax levy is the formal action taken to impose the tax, usually by a vote of the taxing district's governing body. The property tax rate for each taxing body is computed separately. To arrive at a property tax rate, the total monies needed for the coming fiscal year are divided by the total assessments of all the real estate located within the taxing body's jurisdiction. The property tax rate may be stated in a number of ways. In many areas, it is expressed in mills. A mill is 1/1000th of a dollar, or $0. The property tax rate may be expressed as a mill per dollar ratio, for instance, in dollars per hundred or in dollars per thousand. A property tax rate of 0.032 or 3.2% could be expressed as 32 mills, or $3.20 per $100 of assessed value, or $32 per $1,000 of assessed value. A property owner's tax bill is computed by applying the property tax rate to the assessed valuation of the property. Taxation timetable. In North Carolina, in January of each tax year, all taxable real property must be listed in the county in which it is located. All listed property is assessed at its fair market value. Real property is appraised based on a statutory schedule and then is reappraised every 8 years, a process referred to as octennial reappraisal. Real property may be reassessed more frequently than every 8 years. In addition, the county or city may choose to make horizontal adjustments in the 4th year after reappraisal. This means the values of certain types of property or of properties within certain areas may be uniformly adjusted to current value by applying an across-the-board percentage increase or decrease. Each county or municipality determines the appropriate property tax rate every year as part of its budgeting process. The rate is calculated by dividing the total amount of revenue needed by the total assessed value of all the property in the county or city. A new property tax rate must be established by July 1st of each year, or the property tax rate from the previous year will stand. Property tax rates are usually expressed as a certain dollar amount per $100 of assessed value. Per the Machinery Act, assessed value must be equal to market value, at least at the time the assessment is established. In North Carolina, it is typical for sellers to be charged for taxes through the day of closing. Consider these 3 possible scenarios. A settlement takes place on March 15th. Taxes could not yet have been paid by the seller since collection is not possible until September 1st. Thus, the seller would owe the buyer for 75 days of taxes. On a settlement statement, the seller would be debited and the buyer credited for 75 days of taxes. A settlement takes place on October 20th. Taxes have been paid for the entire year by the seller. Thus, the buyer would have to refund the seller for 70 days, the remaining days of October as well as all of November and December. The settlement statement would reflect that the buyer is debited and the seller is credited for 70 days of taxes. A settlement takes place on October 20th. The taxes have not been paid yet by the seller. Common settlement practice is that the settlement agent would collect the monies owed by the seller as well as the monies owed by the buyer to pay off the tax. The seller would be debited for 285 days and the buyer would be debited for 75 days. Settlement agents usually place these amounts of taxes on the settlement statement as expenses to the appropriate parties. In other states, buyers may be charged for taxes beginning on the day of closing. Practice problems on tax prorations will be discussed in more detail in Unit 21. North Carolina property tax liens. As noted earlier, property taxes are liens that attach to real property as of the listing date. In other words, even though property taxes are not due until September 1st of any given year, the tax lien takes effect the previous January 1st. Remember, this tax lien takes priority over all other liens. Appraisal versus assessment. The appraisal of real property may be defined as a process or an opinion as to value of property and how that value is communicated. The assessment is an official valuation of property for the purpose of establishing assessed value for tax purposes. Even though similar in concept, the techniques used in appraisal and assessment are quite different. Tax assessors do not have the time to assess individual properties like appraisers for reasons such as loan applications. In the assessment process, one method routinely used is the mass appraisal technique that determines assessed value for all lands in a given area by applying an overall percentage increase or decrease. This method is often used in North Carolina in conjunction with a horizontal adjustment. Real property may be subject to reassessment if substantial improvements are added to the property. Special assessments. Special assessments, the second category of real estate taxes, are special taxes levied on real estate for public improvements made to that real estate. Typically, an assessment is levied for an entire neighborhood or area that has sought improvements from the government. Property owners of properties that benefit directly from the improvements are required to pay for them. Special assessments are authorized for the installation of paved streets, curbs, gutters, sidewalks, storm sewers, street lighting, beach erosion drainage projects, and water control, to mention just a few. Because these improvements increase the value of the affected properties, the owners are, in effect, merely reimbursing the taxing entity for that increase. Either a county or a city may levy the special assessment, and statutes regulate how the assessment is to be prorated and levied. While all public work projects must be in the public interest, private property owners who receive a direct benefit from a project may be required to pay for all or a portion of the costs of constructing it. Large assessment bills may be prorated over several years. The possible criteria for determining the amount of the special assessment include frontage abutting the project at an equal rate per foot of project, the street frontage of the lots served at an equal rate per foot of frontage, the area of land served by the project at an equal rate per unit of area, or the value of the land benefited by the project. A North Carolina property owner may appeal the amount of the special assessment, but has only 10 days after confirmation of the assessment roll to file a notice of appeal to the appropriate court, and within 20 days after confirmation of the roll, the owner must deliver a statement on which the appeal is based. The appeal is then tried in court. Special assessment liens are specific liens against the property assessed and transfer with the property. Special assessment liens do not take precedence over ad valorem property taxes, and they are inferior to all prior or subsequent liens for state, local, and federal taxes. However, they enjoy priority over other types of lien, such as mortgage liens. Unlike property tax, special assessments are not tax deductible. Learning objective. Calculate various property taxes. Math concepts. Property taxation tax rates. If a property is assessed for tax purposes at $160,000 at a tax rate of 3%, or 30 mils, the tax will be $4,800. Equalization factors are needed in situations where county property taxes are being collected from several different towns, cities, and villages that are using different assessment ratios within that county. If an equalization factor is used, the computation with an equalization factor of 120% will be $5,760. Property taxation, property taxes. Owners of real property in North Carolina are required to pay annual property taxes based on an assessed value of the property and an annual tax rate. Formulas. Annual taxes equals tax rate times assessed value. Assessed value equals annual taxes divided by tax rate. Tax rate equals annual taxes divided by assessed value. Note, the tax rate is expressed as a dollar amount per $100 of assessed value. If the tax rate is $1.67 divided by $100, the property owner will pay $1.67 for each $100 of assessed value. The assessed value can be divided by 100 and the result multiplied by $1.67 to get the annual taxes, or divide the $1.67 by $100 and multiply by the assessed value. Example 1, if the tax rate is $1.67 divided by $100, and the assessed value is $120,000. What are the annual taxes? $1.67 divided by $100 equals 0.0167 times $120,000 equals $2,004 annual taxes, or $120,000 divided by 100 equals $1,200 times $1.67 equals $2,004. Example 2, if the annual taxes are $1,800 and the assessed value is $110,000. What is the annual tax rate? $1,800 divided by $110,000 equals 0.01636636, rounded to 0.0164 times 100 equals $1.64 divided by $100. Example 3, if the tax rate is $1.20 divided by $100, and the annual taxes are $1,200, what is the assessed value? $1,200 divided by 0.012 equals $100,000 assessed value. In some states, the tax rate is expressed in mils, or 1/1,000th of a dollar. Example 4, if the tax rate is 24.5 mils per $1,000 of assessed value, and the assessed value is $125,000, what are the annual taxes? $125,000 divided by 1,000 equals 125 times 24.5 mils equals $3,062.50 in annual taxes. Property taxation timetable. If a city has an annual budget of $705,600 and has property within its jurisdiction with assessed value of $78,400,000, this year's tax rate would be $705,600 divided by $78,400,000 equals 90 cents per $100 of valuation. If the tax rate were 90 cents per $100 of value, a $90,000 home would get a tax bill for $810. $90,000 divided by $100 times 0.90 equals $810. If the tax rate were only 80 cents per $100 of value, the same $90,000 home would get a tax bill for $720. $90,000 divided by $100 times 0.80 equals $720. Each year's North Carolina property taxes are legally due and payable on September 1st. However, because interest does not begin accruing until early in January of the following year, most people pay their real property taxes in late December. The last day that current real property taxes can be paid without penalty is January 5th of the following year. It is worth noting that even though cities and counties operate under a fiscal year, taxes are prorated based on the calendar year. North Carolina taxation timetable. Property taxation special assessments. Assume that a property owner lives on an unpaved street. The city is petitioned to pave the street and agrees to do so. The paving cost is $24 per front foot, and the city is to pay 30% of the cost. If the homeowner's lot frontage is 100 feet, what will be his special assessment tax for street paving? Remember, the street has two sides and the property across the street must bear its share. The steps to answer this problem are: 100 front feet times $24 equals $2,400. $2,400 times 70% equals $1,680. $1,680 divided by 2 equals $840. Key point review. An encumbrance is a claim, charge, or liability that attaches to real estate and may be one of the following. Lien is a claim of a creditor or taxing authority against the real property of a debtor that is used as security to ensure repayment of the debt. Note the following: a lien is not an ownership interest in real estate. It is an encumbrance that transfers with it and lessens its value or impairs its use because it binds all successive owners until paid and cleared. If a debtor defaults in payment of debt, a lien holder must bring legal action to force the sale of the property or acquire title. Deed restrictions or covenants, conditions, and restrictions are private agreements that affect the use of land. Lis pendens is a lawsuit that may affect title. A lien is either of the following. General affects all of a debtor's property, both real and personal. General liens include judgments, estate and inheritance taxes, decedent's debts, corporate franchise taxes, and IRS taxes. Specific affects only identified property. Specific liens include a vendor's lien, a mechanic's lien, a mortgage lien, a real estate tax lien, and a lien for special assessments and utilities. Note: in North Carolina, private residential and commercial construction projects costing more than $30,000 must designate a lien agent. Vendors must give notice to lien agent within 15 days of starting work to retain mechanic's lien priority. Owner-occupied, detached, single-family projects are exempt. The North Carolina Commercial Real Estate Broker Lien Act allows a listing agent in a commercial transaction to secure commission with a lien if filed prior to closing. Priority of liens determines the order in which claims will be satisfied. Generally, first to record is first in right. Real estate taxes and special assessments take priority over all other liens. A subordination agreement between lien holders can be used to change order of priority. Easements are rights to use the land of another. An easement appurtenant is said to run with the land when title is transferred. An easement in gross is an individual or company interest in or right to use another's land. An easement is usually created by written agreement between the parties. An easement by necessity arises when land has no access to a street or public way. An easement by prescription is acquired when a claimant has used another's land for 7 to 20 years. The use must be open, continuous, exclusive, adverse, and notorious. The servient estate is the land over which the easement runs. The dominant tract is the one that benefits from the easement. An easement is terminated when the need no longer exists, when the owner of either the dominant or the servient tenement becomes the sole owner. Release of the right of easement to the owner of the servient tenement, if the easement is abandoned, or by the non-use of prescriptive easement. License is a personal privilege to enter the land of another for a specific purpose. Encroachment occurs when all or part of a structure or improvement illegally intrudes on the land of another or beyond legal building lines. Real estate taxes include the following. Ad valorem taxes, based on value of property taxed, are specific, involuntary, statutory liens, and levied by states, counties, municipalities, school districts, utility districts, parks and recreation districts, and others. Property assessments are conducted by county or township tax assessors or appraisers. Assessed value is generally based on sales prices of comparable properties. Land value may be assessed separately from building value and improvements, and different valuation methods may be used for different types of property. Tax rates for each taxing body are computed separately. Mills may be shown as dollars per $100 or $1,000 of assessed value. Regulated by North Carolina Machinery Act, octennial reappraisal is required by statute, but property may experience horizontal adjustment in fourth year. Levied on property that benefits from public improvements. Special assessments are always specific and statutory, may be voluntary or involuntary, are not tax deductible, and are usually paid in annual installments over a period of years.